Hello. Today I'm going to talk about negligent torts. And also, we will speak a little bit about strict liability and a little bit about damages. So, there are three categories of torts, as you recall. Intentional torts, which is covered in a separate video. Negligent torts, which involve injury following a failure to use reasonable care. And then there are strict liability torts. Negligence is a major area of tort which involves unreasonable behavior that causes injury. So negligence takes place when someone who has a duty to act reasonably instead acts carelessly and causes injury to another. The elements of a tort of negligence is those are very important to remember. The first one is a duty of care. Next is a breach of that duty of care. So if you have a duty to act reasonably, and that duty may extend to people like your customers or to your employees or to whatever, and you breach that duty, that's the first part. Then there also has to be causation, and there's two parts to that: causation in fact and proximate cause, and we'll talk about what that means. And finally, there has to be actual injury. So if there's no injury, then there's no real case here, okay, in negligence. But negligent cases can add up to lots and lots of money. All right, duty of care. Without a duty to another person, you don't owe reasonable care. Now, special business relationships between two parties creates a duty to take action and make the business liable for its unreasonable non-conduct. But normally the duty arises out of a person's conduct and activity. In other words, one does not have a duty to avoid injuring others through non-conduct or lack of relation. So, good example of negligence is malpractice. If a doctor is negligent when treating you or doing surgery on you, then there's malpractice. That's a negligence case. And they have a special duty to you to act as a reasonable doctor would act, and they owe you that duty of reasonable care. All right? So a good case to talk about this with is the Iannelli versus Burger King case. So in that case, we have an issue. What if you are a customer at a restaurant and you bring your family there, and some younger people, maybe teenagers, are acting rudely, maybe cursing, maybe bump into you rudely, maybe frighten your children? And does that restaurant have any duty to you as their customer? Well, normally businesses don't have a duty to protect their customer, or landlords don't normally have a duty to protect their tenant against all crimes that could happen at the business. However, there is an exception to that rule, which says if there are warning signs, if it's foreseeable that the safety of the customer or the safety of the tenant or whatever it may be at risk, then yes, that commercial enterprise, such as a restaurant, does have that duty. And so in the Iannelli case, since it was foreseeable that this teenage group was going to escalate their behavior into possible violence against this family, since there was some warning signs there, it was possible that the restaurant could be liable to the customer for negligence, for not preventing the crime. However, generally speaking, businesses don't always have that duty, but when it's foreseeable that there's going to be criminal activity, there can be a problem. In my real estate law class, we talk about a Walmart case where a customer goes to a Walmart in Memphis that's in a neighborhood where there's been a lot of criminal activity, and Walmart fails to properly take security measures in their parking lot, even though they know there's been some crime right there. And so a lady is abducted and killed from that parking lot, and her husband after her death sues Walmart for negligence. And the court will say, well, normally Walmart wouldn't be liable for this, but the cost of providing that security is very low, and she was their customer, and furthermore, it was foreseeable, which is the big test, that this could have happened given all the crimes that have been happening in that parking lot and right in that area. And so the court said, yeah, Walmart may be liable for this, and they may have a duty of care here, and that's a problem. Breach of duty of care, unreasonable behavior that breaches the duty of care that the defendant owes to the plaintiff. Negligence is determined by the likelihood that the defendant's conduct will injure others, the seriousness of the injury if it happens, and the interest to be sacrificed to avoid the potential risk. And sometimes also there can be something called willful and wanton negligence, which is kind of an aggravated negligence, a result of extreme lack of due care. So a classic case of negligence would be me driving, 90 miles per hour on Caraway Road if the speed limit's 30 or 40, or even 45. That would be the type of thing that would be basically there's a likelihood that my conduct will injure others. The seriousness of the injury could be pretty large, and the interest to be sacrificed would be my interest in driving fast. That would avoid the potential risk. So this is part of the negligence issue. What is unreasonable? And a jury sometimes does have to decide what kind of behavior is unreasonable. All right. Now, another thing that has to be proven is cause in fact. And so basically, before I am liable to another party for negligence, I have to have my failure to use the reasonable care be the cause of the injury, the actual cause. Now, you can have this chain of causation that goes back forever and ever. Now, if two or more individuals are the cause, then they may both have liability or joint and several liability. And so each of them are liable for the entire judgment, or they can be liable together. Now, proximate cause includes the foreseeability issue. Now, you've got to have both causation in fact and proximate cause. Now, let me give you an example here. Let's suppose I'm driving really fast on an icy road in January in Jonesboro, and I know it's slick, but I don't care. I'm in a hurry. I drive really fast. And because of my negligent driving, I hit a light pole. And I knock it down, and I cause the electricity to go out in the whole neighborhood. As far away as 2 miles away, a little old lady's electricity goes out because I hit that light pole. And her electricity's out for 2 days. In the meantime, little old lady freezes to death. She dies because of this. All right. I guess technically, I was negligent. I acted carelessly. I was the cause in fact. In other words, if I had not driven so fast on an icy road, then the light pole wouldn't have gone down, and then the little old lady's electricity wouldn't have gone out. So I'm the causation in fact. However, there's a second test that has to be met, and that's proximate causation. I'm legally liable only for foreseeable risk that I cause. Now, foreseeable risk that I was causing would be, I had a foreseeable risk that I would hit another car or run over a pedestrian, or maybe cause damage to a light pole by my negligent driving. But the foreseeable risk probably does not include the little old lady 2 miles away from where I'm driving who freezes to death. And so probably, if her family tries to sue me later for negligence, they're probably going to lose their case, even though I was the actual cause or causation in fact. There's no proximate cause because her death was not foreseeable from my negligence. Okay. Another example can be the Palsgraf case, which is an old case that is still taught in law schools today and in many legal environment and business case. It's basically Miss Palsgraf is trying to catch a train, and this is a very old case, back when people rode trains a lot more than they do today. She's trying to catch a train. She's, quite a ways down from where these events happen, but she's standing there, and in the meantime, a pretty good distance away, a fellow's running to catch the train, a train that's late. Miss Palsgraf's waiting on a different train, by the way. So this fellow's running, and he's late, and the train starts moving, and he's running, and he's trying to catch it, and the employees of the railroad help this fellow jump on a moving train. Well, the fellow is carrying an unmarked package, and inside that package are some fireworks. And unfortunately, or I don't know if there were fireworks or explosives, can't remember. Anyway, unfortunately, when he's jumping on the train, he drops the box and it explodes. Well, the explosion causes a problem for Miss Palsgraf. Even though she's standing very, very far away and waiting on a different train, a scale tips over, a very large scale tips over and sort of crushes her, and causes her great injury. And that was all actually caused, or the causation in fact was the negligent helping of this guy onto the train. But the court said it was not foreseeable that this would injure someone many, many feet away down there, because the box was not marked, so the railroad employees could not know that it was explosives. And they also would not foresee that someone so far away would be injured by them helping this guy on the train. And so the court said, railroad, you're not liable because your carelessness was not the proximate cause. Even though it was the causation in fact, it was not the proximate cause of Miss Palsgraf's injury. All right, there are some defenses to negligence that you need to know. First of all, there's contributory or comparative negligence. Now, contributory negligence would say, for example, if I'm driving really fast down Caraway Road, and so I'm careless in my driving, but you're also crossing Caraway Road at night, wearing all dark clothes, not on a crosswalk, and not looking where you're going, so you're negligent too. And I run you over with my car. Well, yes, I was driving too fast. I did something wrong. However, you were also negligent. So if you sue me in a contributory negligent state, they would have said, sorry, plaintiff, I know that you're upset that she drove too fast and was driving negligently, but you're also at fault in part, and so you get nothing as a plaintiff. Now, that is sort of an older rule, but it's been modified to make things a little more fair. Let's suppose the court says that I, the car driver, am 70% at fault, and you, the pedestrian, are 30% at fault. A jury would have to measure that, and then if they said, okay, you're 30% at fault, but your damages are $100,000, we're going to reduce that by 30%. So you only get $70,000 instead of $100,000 from me, the defendant, because you were partially at fault. And that's kind of what happened. I'm still sitting here with my McDonald's caution I'm hot coffee, and that's sort of what happened to Miss Stella Liebeck when she sued. The jury said, well, she had some fault, so we're going to reduce her damages by a certain amount. But still, she got quite a bit of money, but they did reduce it some because they said she was a bit negligent. I think it was 20%, if I remember correctly, in the way she was opening the coffee cup. But the jury still felt McDonald's was mostly the negligent party. So they gave her part of her money, but not quite all of it because part of it was her fault. So states are tending to go more toward comparative instead of contributory negligence. In other words, they're saying that people like Stella Liebeck should still get some money and not be denied an entire lawsuit, even though they were partially to blame. Another affirmative defense is assumption of risk. If I go to a hockey game and I'm hitting the head with a hockey puck, or I go to a baseball game and I'm hitting the head with a foul ball, well, I have knowingly and willingly undertook this activity, knowing the risk, and that may be enough that, assumption of risk. In other words, when I try to sue the baseball team for hitting me in the head, I may lose my case because the court's probably going to say I assumed that risk when I attended the game and sat in the seats that I picked. Strict liability and tort is another area that I want to briefly mention. You remember at the beginning I showed you there were 3 types of torts: intentional torts, negligent torts, and then there are strict liability. Strict liability does not look at, it's not intentional and it's not negligent. It's just you're liable regardless of the intent or fault of the defendant. So things like product liability. If you sell an unjustly dangerous faulty product that causes injury to a user of the product, then you're strictly liable. Now, if, there's a production defect, like not created to standards, or a design defect, injury caused due to unsafe design. For example, if you have faulty airbags that you have produced or designed that causes injury, then you may have strict liability regardless of what else is going on there. Now, also ultra-hazardous activities, like if you're transporting and using explosives and poisons, you may have strict liability regardless of whether you're at fault. If you keep dangerous wild animals, this could be an issue for you, and you may be strictly liable even if you do the best you can to keep those animals enclosed. You may have strict liability if they injure someone, regardless of your fault. Artificial storage of large quantities of liquid is another one. Now, other types of strict liability torts, one that comes to mind very quickly is dram shop acts. Tavern owners or bar owners. If you have a customer who gets completely intoxicated at your bar and you don't stop this, then you may be in a situation where if that intoxicated customer goes out and drives their car and injures someone, even though really you didn't feel like it was your fault, you feel it's the customer's fault, you still may be held strictly liable for the injuries to that person who was hurt by the drunk driver. Damages. Usually we have 2 types: compensatory, which is for injury suffered. Now, I should go back. I said usually we have 2 types. Really, I mean, normally you may only have one, which is compensatory, but sometimes courts want to punish defendants and they'll add on punitive damages. Just like in, yes, you guessed it, the McDonald's hot coffee case, you've got the situation where, a court may want to punish a defendant and stop their bad behavior or make them an example. But most of the time you're going to have compensatory damages and not punitive. Now, compensatory damages basically compensate the plaintiff for past and future medical expenses, past and future economic loss, such as losing their car if it's a car accident, past and future pain and suffering. And juries will usually decide the size of that, although judges do give some instructions to the jury about how to figure out. And the jury has to figure out, okay, how much money is this worth, all of this pain and suffering? They have to measure it somehow. Now, sometimes, if specifically, specifically for intentional torts, but also sometimes for some negligence, there will be punitive damages in some states. Some companies will carry liability policies to cover that. Some states prohibit liability coverage for that. And so the company just has to pay it. This is awarded by a court to punish the defendant. Now, normally because of due process concerns, the courts are going to limit the punitive damages to be no more than 3 or 4 times the amount of compensatory damages. So they're not going to allow me in a case where maybe I sue you for $100,000 because you ran over my foot, and then I try to also sue you for punitive damages of $30 million. Well, a court is generally not going to permit $30 million on a $100,000 compensatory damage. Punitive damages should be closer to $300,000 or $400,000 on that case, if at all. to punish you if you, for example, if you did it intentionally. All right. So thank you very much for listening. I hope that this has been enlightening to you about torts and how important they are to your knowledge of your own personal legal rights and also your knowledge of business law. Thank you very much.